Good morning. Today we are going to start with the topic liability. Okay. Now, rights and duties are being created by law for the individuals. Means the modern society, the civilized societies, what they have done, they have created rights and duties of every individuals, and they are regulated by law. Now, when the duty is been given to an individual, if this duty he breaks, and because of this breach of duty he is arising or he is doing injury to any other person, then the person who does that breach of duty, he should be made liable. Means when we use the word liability or liable, when a person does a breach of a duty, a breach of a duty is called as a wrong. He has done some wrongful act, therefore damages, therefore injuries are being caused to other persons. Therefore breach of duty is called as a wrong. One who commits a wrong is said to be liable. Therefore, what is liability then? Liability is a bond, it is a relationship between that wrongdoer and the remedy for which he will be liable, he will be responsible. We will see the definition of Salmon. Okay, what Salmon is telling: liability is a bond of necessity that exists between the wrongdoer and the remedy of the wrong. The remedy of the wrong may be punishment, the remedy may be giving compensation, and he has to do it, he has to face it, he has to suffer it. Therefore, the relationship, the bond between the two, that is the remedy and the wrongdoer, that bond is called as liability. I'll repeat the definition again, it is a very nice definition. Salmon's definition: liability as a bond of necessity that exists between the wrongdoer and the remedy of the wrong. Okay, now what Austin is telling: liability consists in those things which a wrongdoer must do or suffer. Must do means he has to pay compensation, he has to do certain things which the court directs, isn't it? So what he has to do or suffer, he also calls this liability as imputability, means the person has to suffer something. Okay, I'll repeat the definition of Austin: liability consists in those things which a wrongdoer must do or suffer. Okay, means he must do something because he has done a tort, and the main remedy in tort is what? Giving compensation. He has to suffer means punishment, that is a penal liability. Okay, now when liability arises, whether I am liable now, whether you are liable now, no, we have not done any wrong. So when you do a wrong, liability arises. Liability arises from a wrong or a breach of a duty in law. Therefore liability arises only when some wrong occurs. Okay, there are many types of liability. The main types are civil liability and criminal liability. We will see these liabilities. Okay, now civil liability: when a person can be called as liable in civil law when he does some wrong relating to civil aspects, isn't it? Means this wrong, this breach of duty is towards a particular private person. Who files a case here? A private person. Okay, means a wrong against a private individual, that will be called as civil. A tort is a civil wrong. Tortious liability arises from a breach of a duty primarily fixed by law against persons generally, and it will be filed in a civil court for unliquidated damages. So a civil liability occurs when some wrong relating to civil aspect is being done, and the main remedy here is what? Compensation, damages. Here the act is important, not the intention. Intention is not taken into consideration in civil aspect. Why you have encroached the provisions, why you have not paid the money, why you have why the surety is not paying the money, then why intention is not here required in civil aspect. You have promised to do this, you have to do this. What your intention is, that is not considered here. That is civil liability. Okay, tort is a civil wrong, or a breach of a contract also, it is a civil case only. Okay, that comes civil liability only. Now a criminal liability. What is a criminal liability? When a person commits a crime. What is a crime then? A crime is an act of commission or omission, isn't it? Which is being forbidden by law. So crime is a wrong against the whole society, not a particular private person. It is a wrong against the whole society. And what are the remedies here? The remedies here is punishment. He has to suffer. As per Austin, he has to suffer. And who files a case? The state files a case. And for crime, intention is very essential. Actus not facit reum, nisi mensit rea. Okay, mens rea is a determining factor. So how you can distinguish between civil and criminal liability? Civil liability occurs when a wrong is being done to a private individual. Here the crime is against the whole society. A private person files a case in civil liability. A state files a case in criminal liability. Compensation is a basic remedy here. Here punishment is a basic remedy. Act is important, not the intention in civil liability. While in criminal liability, mens rea, that is intention, is a main concept. Okay, we have seen civil liability, criminal liability. The next is remedial liability. Ibi jus, ibi remedium. Wherever there is the right violated, there must be a remedy. When law creates a duty, it ensures its fulfillment, ensures a remedy for that. Where there is a breach, there must be a remedy. Ibi jus, ibi remedium. Right and remedy are the two sides of one coin only. What is the purpose of remedial liability? It protects the right of owner. It ensures the specific enforcement of your right. You are having a right, but if the other person who is having a duty is not fulfilling his duty, you can go to the court, isn't it? You can go to the court and the court is going to enforce. The court is going to compel the person to perform that duty. So remedial liability, the purpose of remedial liability is what? First, it protects the right of the owner. Second, it ensures the specific enforcement of plaintiff's right. Whenever law creates, this is a basic concept, whenever law creates a duty, it should enforce the fulfillment of such duty. Means whenever law is creating a duty, it is going to enforce the fulfillment of the duty. However, again there are exceptions for it. Means what will happen here? There will be a duty, but law can't enforce it. Means these are the three exceptions to the rule that when law might accept the right of the plaintiff, yet it may not enforce it. It means, I'll repeat again. What is the basic concept? When right is there, when duty is there, the law should be in a position to enforce that duty. The law will enforce that duty. The law is going to fulfill such duty. Law will help the person, the victim, to fulfill the duty. Okay, means he will compel the wrongdoer to do it. That is the position of law. But for this general rule, there are exceptions. Now what are the exceptions? The first exception is duties of imperfect obligation. Means here duty is there, but it is imperfect. Like in a time barred debt. You owe me money. You have to pay me, but you are denying to pay. Then what I have to do? I have to file a case against you. When I have to file a case against you? Within the limitation period. But if I don't file the case against you within the limitation period, the court is going to dismiss my case because it becomes time barred. Whether the court can enforce you to give me the money? No, because I am late. So the law may say that okay, you are having a right to get back the money, but we can't enforce it. That is called as imperfect obligation. Law recognizes right but does not enforce it. Okay. Now the second is what? Second exception, duties which by nature are incapable of specific performance. There are certain duties which can't be specifically performed. Once a mischief is done, it cannot be undone. You have to accept it. Okay, you will get compensation, but money is not everything in every case, isn't it? Money is not a remedy in every case. But what law can do? Law can't undo it. What has happened, it has happened. Example, take a defamation. Defamation has taken place. It has taken place. Everything cannot be erased. Law will only say, okay, he has done the defamation, you make him liable, you get compensation. He can be made liable in crime also for defamation, he will suffer punishment. But he has defamed. Whether I can get the same position back, whether I can be restituted in the same position as if I am not defamed, no, it cannot happen. Everyone has a right to reputation, therefore corresponding duty imposed on others not to violate such right. But if libel is committed, that is defamation is committed, the specific enforcement of corresponding duty of defendant is not possible, isn't it? Okay. Now the third exception, where specific performance is inexpedient, means performance can be granted here, fulfillment of duty can be there, but it is not advisable, it is not expedient here. Take in the case of in restitution of conjugal rights. Now for conjugal rights, the court can pass this order, but the court can't compel them to live together, isn't it? It is not advisable here because they have to come together. There was take one more example. There was a promise of marriage, there was a contract of marriage, and the person is denying now to marry. The court can't compel here because it is not advisable, because they should come together by love and affection. Law does not enforce the specific performance of a promise of marriage or painting a picture, but normally it awards compensation in such cases. So get compensation and keep quiet. Law, it is not proper here, it is not advisable here to perform those duties. So where specific performance is inexpedient or inadvisable, there are certain categories of cases in which though specific performance is possible, law will not resort to it, where other remedies would satisfy the requirements, or you can say when other remedies are proper here, better don't take those remedies only, don't go for enforcement. So these are the three exceptions for the rule that where law will recognize your right and will enforce the other person to perform it. Fulfillment of duty can be ordered by the court. This is a general rule, and these are the three exceptions. The first is duties of imperfect obligation. Second is duties which by nature are incapable of specific performance. And the third is where specific performance is inexpedient or inadvisable. Okay. Till now we have seen three liabilities: civil liability, criminal or penal liability, and remedial liability. The others we have already seen, that is vicarious liability, strict liability, and liability in negligence. These three liabilities I have already discussed in the lectures in taught. Better you see those lectures. Okay. Bye bye. See you in the next lecture.